The backpack is in, the death penalty is out. Absolutely huge decisions in the Luigi Mangione federal prosecution. Let's break them down. May it please the audience, I'm Rich Schoenstein. This is So Sue Me, a podcast ordinarily about civil litigation, maybe more often than not about civil litigation. But you guys know I am following this Luigi Mangione prosecution both in federal court and in state court. It's a fascinating case, and there are really great, interesting legal issues here, two of which were decided by the federal court today. So we had a hearing downtown, but more importantly, there were two written decisions issued by United States District Judge Margaret Garnett, who has the Mangione case in the Southern District of New York and had heard argument a week or so ago about these massive issues. One issue was, could the death penalty proceed? Could the charges that potentially lead to the death penalty proceed against Mangione? And the second issue was, could that backpack that he had with him when he was arrested in Altoona, Pennsylvania, that backpack that contains the gun, the magazine, the notebook, really the key evidence in the case, could that be admitted into evidence? Let's take a look at both of those decisions. All right, first up, we have a 39-page opinion and order written by this judge on the issue of the death penalty. And essentially, what Judge Garnett ruled is that the two charges that carried the potential of the death penalty as punishment could not go forward as alleged, and she has dismissed counts 3 and 4 because that requirement is not satisfied. That means the case will proceed to trial on counts 1 and 2, which charge the defendant with causing Brian Thompson's death under federal stalking laws. The potential maximum punishment for each of those offenses is life in prison without parole. Count 3 is a capital eligible offense. That is dismissed, as is count 4. So the net is the prosecution in federal court still carries the possibility of life in prison without parole, but no longer has the possibility of the death penalty. I'm not going to get too thick in the weeds of this decision. This was a novel legal issue about whether these stalking charges could be used as predicates, because to get to a death penalty eligible offense under the federal laws, the prosecutors were arguing that the murder was committed in the course of a crime of violence. And they argued that stalking is the crime of violence. And broken down into its simplest terms, what this decision finds is that stalking is not necessarily a crime of violence, and therefore could not be a predicate for the death penalty eligible charges. I found it interesting the judge opened the discussion, the legal discussion, talking about how she has to follow Supreme Court precedent, really making it clear that she's doing her best to follow the law on these issues. And it suggested to me that maybe she didn't necessarily like the outcome, but went where she thought the law took her. This is ultimately a 39-page decision, as I said, with a lot of discussion about the federal stalking statute, the fact that it's divisible into 4 separate crimes, that plays into the analysis, and the fact that they don't necessarily require violence, that fear, intimidation are potentially part of the stalking counts, and that's why it's not necessarily a crime of violence and can't lead to imposition of the death penalty. We get a lot of analysis here. This is the kind of decision you get in federal court. These are thick decisions, lots of case law cited, lots of analysis. I'm sure the judge and her clerks worked hard on this decision to try to set it all forth and get where they thought they needed to go. Now, what's really fascinating about this is that decision, striking counts 3 and 4 and removing the possibility of the death penalty, that is potentially appealable. The prosecutors can appeal that decision on an interlocutory basis. That means they can do it right now while the case is still pending and try to go up to the Second Circuit Court of Appeals. And if they failed in the Second Circuit, potentially to the Supreme Court. They can take that issue on appeal and try to get the charges reinstated. Here's the big issue. That takes time. And as currently situated, this case is going to go to trial with jury selection starting in September and trial possibly starting as early as October. And if the government decides to appeal the death penalty decision, there's no way that's going to happen. At the hearing today, the judge asked prosecutors if they knew whether or not they would appeal. They said they don't yet know, and she asked to let her know within the next 30 days. So the prosecutors, probably in conjunction with the Department of Justice, have to make a decision here. Are they going to try to get the death penalty charges reinstated, or are they going to plow ahead with prosecution and go to trial? And what makes that even more interesting is you may have heard earlier this week that the prosecutors in the state court case asked that judge to start trial on July 1st. And part of the response to that by the defense has been, we can't go to trial in the state court proceeding on July 1 because we're going to trial in the federal court proceeding in September. That's not enough time. That's fair. That's unfair. That's too much trial too quickly. But if you take the federal case off the docket for an appeal, there's really no reason you can't go ahead with the state court trial. Remember, in the state court proceeding, the defense was successful in getting those terrorism charges thrown out so that the charge there is second-degree murder, and the top potential penalty is life in prison, but with the possibility of parole. Neither the state nor the federal case have the possibility of the death penalty. The state case could get life in prison with the possibility of parole. The federal case could get life in prison without the possibility of parole, which is still a more severe penalty. Do federal prosecutors want to keep the current trial dates and move this case forward to trial and get that maximum penalty, or do they want to go back? I'm fascinated to see what they decide. I can see an argument either way, although I think this death penalty argument is going to be tough even on appeal, meaning I'm not sure they have a great chance of prevailing on appeal, and that's going to have to factor into the analysis. Do they want to potentially delay the trial, let the state court go first, even if they might not win or don't have a great chance of winning the appeal? Very interesting. All right, let's take a look at the other decision that came out today. In the second opinion in order today, Judge Garnett denied defense's motion to exclude the backpack. Again, that backpack that was taken from Luigi Mangione in Altoona contains by far the most significant evidence in the case. Essentially, the judge ruled that the backpack search was valid on 3 different grounds. And remember, the federal court proceeding didn't have as much evidence, as many witnesses. In fact, I think they only had 1 witness. And that state court proceeding on the same issue went on for 3 weeks. And I'm going to tell you right now, this decision in federal court doesn't necessarily mean that they'll reach the same decision in state court. But the federal judge ruled that the backpack search was appropriate on 3 different bases. Number 1, safety. The federal judge found under the circumstances where you had a potential murderer, where there was some indication of sort of terrorism adjacent motivation, that it was appropriate for police officers to search that backpack to make sure it was safe. It didn't contain any unsafe objects. Secondly, the court ruled that it was appropriate as an inventory search upon the arrest of Luigi Mangione, following the procedures of the Altoona Police Department. And third, the court found that it was okay under the inevitable discovery exception, meaning that one way or another, this backpack was going to be searched. So for any 3 of those reasons, safety, inventory, or inevitable discovery, the search of the backpack was sustainable as a legal basis, and the backpack and all of its contents can go into evidence. In sum, numerous exceptions to the warrant requirement, as well as the federal search warrant actually issued, preclude suppression of the backpack and its contents in the case, whether through the discovery of the loaded magazine during a pre-transport safety search, the recovery of the remaining items in the course of an inventory search at the police station, or the inevitable discovery of all of the contents through the federal search warrant, even excising references to any items found or seen after the magazine, firearm, and/or silencer were found. Accordingly, the motion to suppress the backpack and its contents is denied. By the way, that decision, too, is potentially appealable, this one by the defense that can appeal the decision to allow the backpack evidence in, although that kind of appeal is not ordinarily done on an interlocutory basis. That's reserved for after trial in case there's a conviction. So this is an issue for appeal should Luigi Mangione be convicted of anything in the federal court, but probably not an issue for appeal now. And I think it's very significant. I understand there's other evidence outside of the backpack, but the things in the backpack, the gun, the magazine, the silencer, the notebook, the things in the notebook, that seems to me by far the most compelling evidence against Luigi Mangione. It was in his possession at the time of his arrest. That is really important evidence for the prosecution. This decision is probably the most important evidentiary decision that's been made or will be made in the case. And it doesn't mean, as I said, that they have to come to the same result in the state court, although I'm sure state court prosecutors will refer to the federal decision as precedent. But the state court heard much more extensive testimony and got other evidence in the 3-week hearing they held on this issue. And state law is a little different. They don't really apply this inevitable discovery doctrine the same way as federal court. You could get a different outcome in the state court proceeding. That might be relevant to one side or another figuring out which trial they want to go first. Do they want the state case to go first or the federal case to go first? If you think there's going to be a difference in the evidence presented, that might affect your view. One other thing you might have seen in the news, I know it was reported yesterday that some dude showed up at jail with a fork and a pizza cutter and I guess fake ID and fake papers in some sort of effort to bust Luigi Mangione out of prison. These kind of implements are not sufficient for that task. If you ever are in the mood to get somebody out of prison, I don't suggest you bring a fork and a pizza cutter to that endeavor. And I don't know at all what's up with that person who tried to do it. That seems sort of crazy to me. And we'll see what happens in terms of him. He's obviously under arrest and is going to face some really steep penalties. We don't take trying to bust somebody out of prison lightly in this country if that was a genuine attempt to do so. Anyway, much less important that than these developments today in the federal case. So there was a short hearing downtown after these two decisions were issued. The judge checked in with the parties about the timing. The judge checked in with the government about whether or not it's going to appeal the death penalty decision. So they have 30 days to report back. There are some other pretrial things that'll be going on in the federal case. They're due back in August for another hearing, and then I believe they're due in September to try to pick a jury. That'll be a very complicated task because everybody in New York has heard about this case, and a huge number of people have an opinion about the case. And obviously, you have to get a jury that hasn't already decided the case, that is willing to hear the evidence and make a decision. So let's just summarize where we stand in the two prosecutions against Luigi Mangione. The federal case, there are still 2 charges of stalking/murder. Those are punishable by a sentence of life in prison without the possibility of parole. That's the maximum punishment. We're on schedule for September jury selection and trials starting as early as October. There is the possibility that the government will want to appeal the dismissal of the death penalty charges. That would certainly delay proceedings if that happens. So that's the big thing to keep an eye on. And in that regard, of course, it was the federal government that pushed to make this a death penalty case in the first case. This was part of the new administration, their supposed law and order stance, and I think obviously connected to the fact that the victim here is a corporate executive. You don't really see federal cases pursue the death penalty in single victim cases. This is an outlier. Why is it an outlier? Well, because it's a case of renown, because of the timing of the case coming out at the same time as the DOJ was switching leadership, and in my estimation, because the victim is a corporate executive and the current administration wants to protect corporate executives, wants to protect the healthcare industry, wants to protect the insurance industry. Those are all big Republican supporters, and I imagine there's a political motivation to prosecute this case and seek the death penalty. And the big question now will be whether that political motivation, how does that weigh on the scale with the prosecutorial motivation to move the case forward to trial and conclusion? If you're a prosecutor, you always want to get that case to trial. You want to get in front of a jury. You want to get your conviction. That's the federal case. The state case has a second-degree murder charge. There is a chance of life in prison, but with the possibility of parole. That is the maximum penalty that can be obtained in the New York State case. The plaintiff has requested that that trial commence on July 1st. The defense has said that's not reasonable or possible, and it remains to be seen what the judge will do, if the judge will try to leapfrog. Ordinarily, prosecutors would sort of cooperate and decide who goes first. I just don't think there's that kind of cooperation these days between New York State prosecutors and federal prosecutors. Part of where we're at is we don't have those traditional relationships in place, and sort of each case is left to fend for itself, and each set of prosecutors wants to push the case to trial as soon as possible. It remains a very interesting case, obviously an important case because of the allegations, a very interesting case because of all the legal issues. We'll keep following it here. I'll be back at you. So subscribe, like the video, do all that kind of stuff, please. Make us part of your YouTube viewing. We'll be back with more episodes. For now, we are adjourned.